Good evening, everybody. We're ready to start. My name's Abra Murray, and on behalf of the Board of Student Advisors and Dean Elena Kagan, I welcome you to the final round of the Ames Moot Court competition. The case before the court tonight, Ames Markets Incorporated versus Aphrodite Cosmetics Incorporated, was written by Merrill Kessler, HLS 93, and Julie Barton, HLS 92. The case presents a question of prudential standing and a question regarding commercial speech. Petitioners, Ames Markets Incorporated, is represented by the William Wirt Memorial Team: Jim Farnsworth, Erica Harold, Kimberly Olvey, Skylar Showden, James Wierzeniak, and Cassandra Welch. Erica Harold and Cassandra Welch will be arguing on behalf of the team. The respondent, Aphrodite Cosmetics, is represented by the Shireen Shakur Memorial Team: Elizabeth Edmondson, Mark Jensen, Tien Miamin, Samuel Miller, Charte Kwarku, and Kevin Terrazas. Tien Miamin and Kevin Terrazas will be arguing for the respondents. The Honorable Justice Anthony Kennedy of the United States Supreme Court will preside as Chief Justice for this final round. Joining him will be the Honorable Merrick Garland of the Circuit Court of Appeals for the District of Columbia, as well as the Honorable Diana Gribbon Mott of the United States Court of Appeals for the Fourth Circuit. Please hold all of your applause until all the oralists have finished, and remember that Petitioner will be making rebuttal arguments after Respondent has spoken. You will have an opportunity to take pictures when the judges first enter. We ask that you refrain from any flash photography thereafter. Also, we ask you remain seated while the oralists are speaking. Please turn off all of your cell phones and pagers now. We hope you enjoy the argument, and good luck to everybody.
All rise. The Honorable, the Chief Judge, and the Associate Judges of the United States Court of Appeals for the Ames Circuit. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the Ames Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good evening. The court is sitting to hear one case to be argued. The case is Ames Markets, Inc., the petitioner, versus Aphrodite Cosmetics, Inc., the respondent. Is counsel for the petitioner ready? You may proceed. Good evening, counsel.
Good evening. Mr. Chief Justice, and may it please the court. My name is Erica Harold. I represent the petitioner, Ames Markets, and I'll be arguing the first issue before this court, whether Ames has prudential standing under the Lanham Act. My co-counsel, Cassandra Welch, will then argue the second issue on appeal, whether Aphrodite's speech was commercial. When the lower court denied prudential standing to Ames, it restricted the Lanham Act in a manner contrary to congressional intent and violated the separation of powers. Reversal is therefore required for the following two reasons. First, Ames claim is encompassed by the Lanham Act's remedial purpose and its plain language. And second, no articulable considerations of statutory policy justify denying Ames a trial on the merits. This court in Blue Shield of Virginia versus Mccrady said that the heart of a prudential standing inquiry in a statutory context is trying to effectuate Congress's intent.
Well, Ms. Harold, if I could just ask you at the outset, As I understand the respondent's brief, correct me please if you have a contrary understanding, Article 3 jurisdiction is not contested.
That is correct.
There is a close interrelation, of course, as you get to the outer bounds of prudential standing. Suppose that the Congress said that anybody in the world could sue under circumstances, no matter where they were living, where they're located, if they bought one a bottle of this lotion. Would there be Article 3 jurisdiction in that instance?
Well, Congress would not have the ability to abrogate Article 3 standing, but the court would be within its discretion to decide in the instant case whether or not granting standing would be prudential. It could look at whether...
No, but I'm asking about basic Article 3 jurisdiction in the hypothetical case that I put, and that's not a matter of discretion. In fact, we have the obligation to inquire into the point.
Congress would not have the ability to abrogate Article 3 standing.
My question is, if Congress enacted such a statute, would that be consistent with the requirements of Article 3 jurisdiction? Anybody in the world who bought one bottle could bring a suit.
It would be consistent with Congress's power, but a court could decide that it would not be prudential to grant standing to all of those plaintiffs. They would then look to see what type of interest was Congress...
But you say that there's no Article 3 problem in Congress doing that.
I see no Article 3 problem if a plaintiff is able to show that it has an injury, that it was directly injured in some way by the defendant's conduct.
So any injury, no matter how small, worldwide, Article 3 standing. And then it's just a question of prudential standing.
That is correct. This court said in Blue Shield of Virginia versus Mccrady that not only is the court supposed to ascertain Congress's intent, but it's supposed to try to effectuate and grant standing to those plaintiffs that bring the type of interest that Congress was interested in protecting.
But you cite the case for presumption. I looked at the case, and I don't think we have a presumption in favor of jurisdiction. In fact, I should think it would be quite the opposite, particularly when what is at stake, as we'll hear from your co-counsel, is the whole question of protected or non-protected speech. To say there's a presumption of prudential standing, that seems very strange to me.
Blue Shield of Virginia versus Mccrady doesn't use the word presumption.
Yeah, but you did in your brief. It seems to me that you're greatly expanding the holding of that case. You're characterizing it with a word that wasn't used in the opinion.
Blue Shield of Virginia seems to stand for the proposition that if a plaintiff brings a claim that falls within the Lanham Act's plain language and remedial scope, that the court would then have to be able to articulate some particular considerations of statutory policy in order to justify denying standing.
I guess I was a little puzzled by the word presumption, too. Did you find that in any of this court's jurisprudence? A presumption of prudential standing?
We did not find it
in any area of the law?
The way in which we would anticipate the presumption operating would be the way in which this court used the word presumption in Wheat versus United States when it was looking at the defendant's right to counsel of choice. So it's being used more to articulate a way in which interests should be balanced. We are not maintaining that this court has previously done that, however.
Well, but in part of the defense of your own proposition, you said on page 6 of the brief, not the printed brief, which I just received, but the typed brief, that the tests of standing do not capture our intent. You mean we've done a lousy job in writing our opinions? I didn't quite understand.
I would never mean to suggest that, Your Honor. Could you clarify the part of the brief?
Well, but you say that the tests that we've used don't really capture our intent, which means that we haven't written with sufficient clarity? I don't understand the point.
The way in which the Ames Circuit Court applied its prudential standing inquiry is not consonant with the way in which this court said that prudential standing assessment should be done. This court has said that you start with the Act's plain language, you then look at the remedial purpose, and if the plaintiff's claim raises those types of interests that it seems Congress was interested in protecting, then there would be required to have articulable considerations of statutory policy.
When you talk about remedial purpose, can I ask you this? it seems to me that a lot of the cases that you cited dealt with substantively remedial purpose. Did they use the remedial purpose of the statute to extend prudential standing?
Remedial purpose is relied upon to talk about the broad construction that should be granted to these types of statutes.
But does any one of them use it as a springboard for prudential standing?
They
Which
do.
you seem to do. You seem to wind up your argument about presumption on the fact that this is a remedial statute, and citing other remedial statutes which you say are construed broadly. But the cases that you rely on didn't seem to me to be cases in which the courts were talking about prudential standing, were they?
That's correct. If I could clarify our position, we were relying upon those remedial statutes to talk about the broad construction that courts usually give to those statutes that provide a remedy, and that was used to contend that the Ames Circuit Court's narrow construction would not be consistent with the way in which statutes are usually construed. The presumption idea is not necessarily a legal term. It's an explicit recognition that when a plaintiff brings an Article III sufficient claim, that it should be required something more than just to do a cursory
But
denial.
I'm not sure what you say. It's not a legal term, but you used it in a brief, and you want us to use it in our opinion. You want us to say there's a presumption in favor of jurisdiction, for which I think is a rather novel, to use a polite word, a rather novel submission.
If I could explain the novelty of our use of that word, it was intended to capture the idea that in Mccrady, this court said there should be something required more than just a cursory denial. And so when I say that we didn't mean it in the precise legal term, what I meant by that is presumption is defined a lot of different ways. Sometimes it talks about switching the burden of proof to the defendant. We did not intend to mean it in that way. We intended it in the way in which this court used it in Wheat versus the United States when they talked about the balancing and the weight that needed to be placed upon certain interests.
So I thought when you meant presumption, you were talking not about our intent, but Congress's. You have a statute that says any person who believes that he or she is likely to be damaged by such act. That certainly encompasses you, if it's read literally. So I took your meaning to be that the presumption is Congress meant what it said and said what it meant. And if the other side doesn't like it, have them show us why Congress's words should not be given effect by this court. Is that what you meant by presumption?
That certainly captures part of what we meant.
That's what I thought. So let me ask you another question. Their argument is that only direct competitors have standing. Your argument is no, that the retailer, in this case, you, has standing. So imagine that I moonlight for Mary Kay, okay?
Will, Your Honor?
And so do all of my fellow judges. And there are a lot of us. And our sales went down. Do we get to sue?
In the instant case, the hypothetical Your Honor just posed, the injury would be less direct than the type of injury that Adam's Apple has brought before this court.
Well, Mary Kay is well known for selling cruelty-free cosmetics. And all of a sudden, there's this big competitor, your opponent in this case, who claims they're selling it. I go door to door in my pink Cadillac, and they tell me that if you sell a certain amount of Mary Kay products, you get a pink Cadillac. It's right there on the website. I go door to door, and they tell me they don't want to buy from me anymore. They want to buy from Aphrodite because now Aphrodite has the same deal. So, do all 1,000 or 1,500 of my fellow federal judges, can we all sue?
You would be able to bring a claim, but a court would be within its discretion to deny prudential standing. Based on the way in which the court in Camel Hair addressed the issue, you would have to be able to show that you were directly injured. And so it would be...
Well, what if I show that the week before the announcement, I feel like I'm arguing your case for you, but the week before the announcement, I sold 1,000 bottles of, I don't know, whatever it is I sell, and immediately thereafter, I sold 0, and all my customers were buying from Aphrodite. Isn't that, what else do I need?
Is Aphrodite still making the representations regarding the cruelty-free
Yes, it's the
nature?
same as this case, except instead of Adam's Apple suing, it's Mary Kay individual distributors suing.
You would first have to establish Article III standing, but the fact that you would not necessarily be able to say you have the same interest in the cruelty-free nature of cosmetics would give the courts one of those articulable reasons of statutory policy to decide that granting you standing might not be in the court's best interest and might not necessarily effectuate.
I guess I don't understand the difference between Justice Garland's hypothetical and the case at hand from your point of view. What is the difference? Why wouldn't the federal judges have jurisdiction if you would have jurisdiction, if there would be jurisdiction here?
The judges would have jurisdiction in both cases.
I know they'd have Article III jurisdiction, according to you, but why would a court decide not to exercise prudential jurisdiction there and would here?
They may very well grant standing in the hypothetical that was posed regarding Mary Kay, but the difference would be that with the Mary Kay salespeople and sales judges, they would not necessarily be claiming they had the same interest in cruelty-free cosmetics that Adam's Apple is maintaining. And that's one of the factors that courts look at in trying to determine if granting standing to a particular plaintiff would lead to speculative damages.
You know, I heard you say that. What do you mean the same interest?
Looking at whether or not you have an interest that in maintaining the reputation of a particular characteristic. So in the camel hair case, the interest at stake was that of cashmere. In this case, the interest would be that of cruelty-free cosmetics. And so if you can maintain that you have an interest in maintaining that type of high quality and the type of reputation, the type of injury that you might be claiming might be seen as more direct than a...
Yeah, but according to the hypothetical, these were all, I thought, also safe cosmetics, not animal-tested cosmetics. I mean, it's exactly the same situation, except there are all these independent folks in Cadillacs.
I may have misunderstood Your Honor's hypothetical. If Mary Kay salesmen were saying that they necessarily sold cruelty-free cosmetics, they would have the same type of interest. However, the court has never said that you have to compete on the same economic level, so that would not be the disqualifying factor. A court could then look at a whole host of other factors. They could look to see if the type of damages that you'd be claiming would be...
Let me test the theory that's in your brief and that you've just been explaining before I interrupted you, but your time is going. I want you to assume this case. There are two competitors. They both sell steel supplies. They are within about 2 miles of each other. One competitor decides he's going to cheat the state of New York by not paying sales tax. That enables him to give his customers a lower price because he doesn't remit the sales tax to the state of New York. Over a period of 12, 18 months, he's beginning to get more and more customers. Can his competitor sue? Can the competitor who is paying the tax sue the cheating competitor on the grounds that he's lost customers to the cheating competitor?
It wouldn't seem that the Lanham Act would be the appropriate statute.
No. I'm just saying from the standpoint of standing. Let's say it's a RICO statute.
Under the RICO statute?
Yes.
I'm not familiar with the specifics of the RICO statute.
Well, assume it's a federal offense to engage in a scheme in a coordinated way, which deprives the government of its tax. It's a tax fraud. It's a criminal act. Do you think, under ordinary principles of standing, assuming there's a federal cause of action, that the one competitor can sue for the losses that he sustained by reason of the business going to the other?
Without knowing the specifics of the RICO statute, I'd be hesitant to offer an opinion because I'm not sure what kind of factors...
Well, we had a case on this last term. It's called Anza versus Steel Supply. And we said that there is no standing because business losses may be sustained for many reasons. Courts aren't necessarily qualified to engage on a lengthy undertaking of why you sustain certain business losses. There may be many reasons that Adam's Apple Market lost sales. And our court in that case said that this is an improper inquiry for the court. Why doesn't that apply here?
The RICO statute, from my understanding of it, would be different from the Lanham Act in that Congress was trying to address different types of interests. And so you wouldn't necessarily...
It was trying to combat organized crime, big business fraud, which certainly seems as great an interest as you're asserting here.
Without knowing exactly why the court denied standing, it would be difficult to say what particular factor the court found determinative, because this court, when it does prudential standing inquiries, I know they take into consideration.
Well, the rationale, well, it's difficult to understand for the courts to decide why sales have been lost. There are any number of reasons why sales may be lost.
In the instant case, the district court recognized that Adams Apple was prepared to be able to show exactly how it was harmed and was able to make a showing of what kind of damages it had. It would not be speculative damages. This court's decision in Associated General talked about what is required for finding that damage is either speculative or not. The plaintiff in the Associated General case brought a claim where they did not necessarily say how they had been harmed. They hadn't apportioned directly the damages. Those aren't the kind of damages at play here. So without knowing exactly the reasons by which the court denied standing in the case Your Honor mentioned, I could not say exactly what would distinguish. What I could say, though, is that the Lanham Act protects the types of interests that are implicated by this case, namely providing a broad remedy to plaintiffs who have been injured by false advertising.
Thank you, counsel.
Thank you.
Ms. Welch. Good evening.
Good evening, Your Honor. Mr. Chief Justice, and may it please the Court, Aphrodite engaged in commercial speech when it pledged that it would not test its products on animals and when it assured the public that it had kept that pledge. Aphrodite's statements about its products and business practices are the types of statements upon which consumers are likely to rely and which may cause commercial harm when false or misleading. Aphrodite's statements about its products and business practices should be identified as commercial speech because, first, doing so effectuates the rationales behind the commercial speech doctrine, and second, because nothing in this court's jurisprudence would foreclose such a result.
So why are we talking about the commercial speech doctrine in this case? This is a case under the Lanham Act. That's a statute. Why should we think that in 1946, when Congress passed the Lanham Act, they expected that the scope of liability would depend on a commercial speech doctrine which wasn't even thought of until the 1970s, was changed twice by this court in the 1980s, and which you're proposing yet a new formulation of after 2000? Why don't we just look at the words of the statute? Why should we be looking at First Amendment for purposes of the Lanham Act?
The words of the statute look toward commercial advertising or promotion, and that is never defined in the statute. So the courts have looked to determine what was meant by those words, and it was determined that there are 4 different prongs that a statement must meet to be considered.
But the 4 prongs are prongs for interpretations of the First Amendment, not of the Lanham Act. And I don't see any indication that Congress thought in 1946, or when it had amended it in the 1980s, that what they were doing was mimicking a constantly changing view of commercial speech under the First Amendment. Why do you think that Congress had that in mind?
The 4 prongs to which I was referring were those identified in Coastal Abstract that were not dealing with the constitutional aspect, but were identifying one part of whether a statement should be identified as commercial advertising or promotion, being whether it was commercial speech.
So you think that these are just ways of interpreting the words of the statute and not the First Amendment?
The Lanham Act's interpretation, or the interpretation of what is actionable under the Lanham Act in terms of what is commercial speech, has tracked this court's First Amendment doctrine.
That's what those lower courts, that's what they do. But, you know, this is the first time up here, and we have a chance to decide this. We don't have to pay any attention to what they've done in the past unless they have a good reason. So what's the reason that we should not look at the words of this statute and instead, look at the Supreme Court's interpretation of the First Amendment?
Well, by looking at the Supreme Court's interpretation of the First Amendment and by looking at what is commercial speech, it gets to a lot of the same principles that underline the Lanham Act, because when this court has been identifying the commercial speech doctrine, it has recognized that it is important to do so because of the potential to mislead, and that has been an underlying rationale in this court's jurisprudence pertaining to commercial speech.
You seek injunctive relief in this case?
No, I do not believe we do, Your Honor.
I thought the complaint sought for injunctive relief, but you would know better. Are you entitled to injunctive relief under the statute if you plead it?
Yes, Your Honor.
All right. Would that be a permanent injunction so that a court would supervise the speech of a corporation on matters that have political and social significance?
It is possible that it could be a permanent injunction in terms of what these false and misleading representations then are. But the court would not have jurisdiction to then look over all of the statements that Aphrodite would make regarding cosmetics testing on
Well,
animal
I suppose
broadly.
if a wrongdoer is subject to an injunction, the court exercises some continuing supervision. And my concern is that if you prevail here on your theory that this speech is unlawful, that you would be entitled to injunctive relief where on an ongoing basis this corporation and any other corporation which came under a similar injunction based on your theory of liability would require courts to be censors over a long period of time.
What it would require is that when corporations are making specific statements about their products and their business practices, and it could be narrowed to, in this case, the particular area about the types of representations, if there was to be an injunction that would follow.
Well, could we presume that if you prevail in your position, that businesses and corporations generally will be reluctant to disclose their views and their policies with reference to political and social matters?
I do not believe that would follow because the proposed test here looks only to representations of fact.
Well, but don't you think any careful business person wants to steer far clear of the potential of litigation? And you say that there can be a liability for statements of political and social significance on which we have a very strong interest in knowing where the various corporations stand. What you're asking for is really, it seems to me, quite a sweeping rule insofar as corporate America is concerned.
The statements that we would argue are commercial speech are only those that are specifically about products, whereas the statements about social concern that Your Honor is concerned about would be those statements that Aphrodite made that included saying that animal testing was inhumane.
You know what image is in modern advertising. Everything is image, and it ultimately is for sales. That's what corporations exist for. And it seems to me you have to confront the very real problem that the rule you're asking for means that it's going to be far less easy for us to understand and have access to the policies that corporations have with respect to the environment, with respect to political, with respect to social matters, especially companies that have plants around the world. We won't know what they're doing because there will be a concern, as in the Nike case, about making representations with reference to their operations. And it seems to me that that's in the public interest to know. You're asking us to censor, to suppress, to punish speech that's in the public interest.
Well, as Your Honor identified, the image and branding of a corporation is very important. Indeed, Aphrodite spends between 1/3 and 1/4 on its annual budget doing that sort of promotion. Yet that is not the type of promotion that this would seek to address under the commercial speech doctrine. And that type of promotion is likely to still exist outside, even if the specific representations of fact are commercial speech. These corporations, because of that economic motivation for discussing their brand and for portraying an image, those statements, which are not commercial speech, are likely to continue because of their economic motivation, which, as this court has recognized, would make them hardier.
Well, I'm wondering why, the scope of how far we're going here and why you think economic speech is any hardier. So imagine Dean Kagan issues a press release in which she announced that the old bad days of the paper chase at Harvard Law School are over, and this will now be a cruelty-free, with respect to students, law school. As a result, applications and acceptances at Yale plummet. Dean Co. sues Dean Kagan. This is under the Lanham Act, a good or services. Why can't, under your theory, Dean Co. sue Dean Kagan? Or perhaps he can.
Well, although Dean Kagan may or may not be acting as a commercial speaker in that case, the representation about Harvard being a cruelty-free school would not seem to be a representation of fact about Harvard itself.
Okay, let's say her example, now this is a real hypothetical. Let's say, just totally hypothetically, let's say she says, oh yeah? Well, we have an ice skating rink outside the Hark. Dean Coe comes here in November, looks outside the Hark, no ice skating rink. This is an objective fact. Can he sue?
That is something that would meet the test. However, it is something that would not be seen as being false or misleading once...
Well, you either have an ice skating rink or you don't. I mean, why isn't that something that's false or misleading?
It's something that the court would look at all the information and would look to see if it would be reasonable that consumers or students would assume that there would be...
And what is your view of the conclusion the court should reach once it takes its look? I mean, you're telling us that's another case. We want you to answer the hypothetical.
Well, once the court did look at that case, it's possible that if it found that Dean Kagan was acting as a commercial speaker, and there have been instances in terms of recruiting where the court has found that that is not a commercial speech statement because it is related to recruiting and it does not...
All right, I'll change the professor. Imagine it's Professor Tribe. Now, here's another hypothetical. Imagine he sends a letter to a law review saying, all treatises are bunk, okay? And actually, he's very persuasive in that regard, and as a consequence, people stop buying poor Erwin Chemerinsky's constitutional law treatise from Duke. His sales plummet. 2 years later, Professor Tribe, who has been secretly working on his treatise anyway, comes out with the treatise and corners the market. His interest is not only, obviously, not completely economic, but he does make money from the treatise. And Professor Chemerinsky's interest is not only economic, but he does lose a lot of money. All treatises are bunk. Is there any reason why you can't sue on that claim?
He certainly may be able to sue, but this test that is proposed today would not necessarily capture that as being commercial speech, because it is something that seems more akin to an overstatement or something that is puffery and not necessarily a representation of specific fact.
Cruelty-free? You don't think that's some overstatement, some puffery?
It is a bit of an overstatement, but when Aphrodite made representations about its product, it did not say that they were cruelty-free. It said that Aphrodite did not test its products on animals. That is a specific representation of fact about its products and business practices, and that should be actionable.
I don't think I understand your position on the Bolger test. If we actually adopted the Bolger test instead of some new test, you seem to be keen on new presumptions and new tests, but if we didn't do that, would you succeed or do you acknowledge that you would lose?
Bolger does not provide support necessarily in either direction in this case. Bolger, by its very terms, is insufficient to determine whether every instance of speech is commercial or non-commercial.
But the way you would have us interpret your test, I thought we were to leave some play in it too. So it wouldn't determine everything either.
Certainly, Your Honor, but the Bolger test would not necessarily reach an outcome in this case, because a mistake that the Ames District Court and the Ames Circuit Court fell into when looking at Bolger was assuming that all of the factors were necessary, but that's not necessarily the case. In this case, there would be an economic motivation in these statements. The specific product references prong would certainly be met because, as this court recognized in Bolger, a company that has a large market share
Would you have an advertisement?
That is something where this court looked at whether or not there was a traditional advertising format. Now, certainly there is an argument that under some definitions of advertising, this would be considered the type of promotion that would be advertising. This would not necessarily be in the advertising promotion, but the two prongs of Bolger, the economic motivation and the specific product reference, can still be strong support for this being commercial speech. And indeed, some lower courts have applied Bolger in the broader way that this court intended and found that even absent one factor, which this court specifically said was possible, speech is commercial, and that would certainly be the case here.
Thank you.
Now, furthermore, there are these specific factual representations that Aphrodite made about its products and business practices should be identified as commercial, and the fact that there may be some non-commercial statements surrounding them should not change that result.
What specific statement besides we pledged to cease all testing of our cosmetics on animals, a pledge we have kept? What other statement besides that do you dispute? Because although you don't plead that in your complaint, that seems to be the one that shows up in the brief.
Well, in the complaint, it was indicated that it was Aphrodite's representations that it did not test its products on animals.
Generally, but you
Yes.
don't quote that. You
And-
quote other portions of that document, but not that portion.
Well, there are 5 specific instances in which Aphrodite made specific representations about its product in terms of animal testing. And it's those 5 representations in the press release, in that letter to the editor, in 2 of its production materials, and also in its code of conduct that would clearly be commercial speech under this test, in which we would identify as being commercial speech.
How would you be able to figure out how much of your damages are due to the objectively false statement for purposes of Rule 12b-6 that we don't test our animals, our cosmetics on animals, and the other statements, we're really great people, we hate testing, we hate testing, et cetera. How would you inextricate these seemingly inextricable points?
The points could have been stated separately, and so the court would look at the individual points and see...
Right, but for damages, I understand your damage theory in the end to be you were making a certain amount of money, they made this awful announcement, you're now making less money, right?
Correct.
How do you know how much of the less money is due to the statement you're talking about, which you say is commercial speech, and not to the more broad social statements which were wrapped around that statement?
The broader social statements had more to do with Aphrodite's branding and Aphrodite's own image, just as Aphrodite developed a theme of be beautiful. That part would not be actionable, but the specific representations could be separated out from that image to look and say, and this Adam's Apple stands ready to provide experts who can testify to look at exactly what it was that resulted in that change in the market that would have resulted in the change of the sales. Identifying Aphrodite's representations of fact as commercial speech is necessary to prevent commercial harm from being imposed on the market. Aphrodite's representations about its products were made to influence consumers, making it likely to cause commercial harm that the commercial speech doctrine was intended to prevent. In order to uphold the rationales animating the commercial speech doctrine, the circuit court should be reversed, and Aphrodite's representations should be identified as commercial speech. Thank you, Your Honor.
Thank you, counsel. Counsel for the respondent, Mr. Terrazas. Good evening.
Good evening, Your Honor. Mr. Chief Justice, and may it please the Court, my name is Kevin Terrazas, and along with my co-counsel, Tien Mayamin, represent the respondent, Aphrodite Cosmetics. In this case of first impression, I will discuss why granting standing to a minimal competitor with attenuated injuries would conflict with the purposes of the Lanham Act and prudential standing.
Do you agree that there's Article 3 standing?
Yes, Your Honor. That has not been brought before this Court, so we will, for this proceeding...
Well, but we have the obligation to inquire into that, don't we?
Yes, Your Honor. The Article 3
and if
standing...
you agree that there's Article 3 standing, why shouldn't we just look at the statute and interpret the statute the way it's written?
Because, Your Honor, prudential standing is an additional barrier to a plaintiff bringing suit based on the statutory requirements. The purpose of prudential standing is to ensure that the party is the one that would best effectuate the statute's purpose.
You think in the instance that I put to Petitioner's counsel, where anyone in the world can bring a suit after buying one small purchase of the product, there's Article 3 standing?
No, Your Honor.
Or you don't agree there's Article 3 standing?
No, Your Honor. Simply by purchasing a product and having some sort of injury.
Well, and then she alleges that there was a misrepresentation and so forth, on facts like this case. No matter how small. See, there's no jurisdictional amount, I take it.
I'm sorry, Your Honor.
There's no jurisdictional amount for bringing the Lanham Act claim, is there?
No, Your Honor. Article 3 is a separate constitutional standing.
Does the fact that there's no Article 3 amount mean that we must be more careful in assessing, A, whether there's prudential standing, and B, be most solicitous to ensure that there's Article 3 standing?
Yes, Your Honor, because we're, in this prudential standing inquiry, are trying to effectuate the congressional purpose.
Well, if you look at the congressional intent, it says, you keep talking about legislative history, but the statute says any person.
Yes, Your Honor.
That seems pretty clear to me.
Yes, Your Honor. And later on in 15 U.S.C. 1127, when it's describing the intent of the act, it discusses that this is limited to commercial entities that can allege or prove an unfair competition violation.
Well,
and so
they clearly are a commercial entity, right?
Yes, Your Honor.
There's no dispute about that.
Yes, Your Honor.
And although you all keep talking about how they have an established standing, we're here on a 12b6 motion. Haven't they alleged enough facts?
No, Your Honor.
Why not?
Because, Your Honor, simply because you have lost sales does not give you prudential standing, does not necessarily show that you have unfair competition.
Well, they're the exclusive distributor
Yes,
of
Your
this.
Honor.
Doesn't that do anything extra for them?
No, Your Honor. In order to prove prudential standing under the Lanham Act, which is a statute-specific approach, you need to show a competitive injury, and they cannot allege that. They can only allege an injury, a commercial injury, but not a competitive injury.
Why, I'm just not following why you say that. You have a statute. It has words. The words are, any person who believes that he or she is likely to be damaged. That's all it says. That person can bring a suit. There's no doubt that these people have alleged sufficiently that they've been damaged, that they believe that they've been damaged. Why would Congress use such incredibly broad language if they didn't intend to use as broad a standing rule as possible?
Your Honor, later on, as I explained, they limit that to commercial entities, so not any person
actually,
could do so.
what they limit it to is, I assume you're talking about the tagline on 1127, where they talk about the intent of the chapter.
Yes, Your
right?
Honor.
So that's weaker already than the specific language where they say exactly who can sue, isn't it?
Yes, Your Honor.
That language says to protect persons engaged in such commerce against unfair competition. Right?
Yes, Your Honor.
Well, I'm not sure why this is a standing question.
Because,
These
Your
people
Honor,
are certainly engaged in commerce. There's no doubt about that, right?
Yes, Your Honor.
Okay, and they believe this is unfair competition.
Yes, Your Honor. And under this Court's jurisprudence in Bennett v. Speer, this Court held that although a statute may be intended to be interpreted broadly, that by itself does not abrogate the prudential standing doctrine. Instead, Congress has to explicitly abrogate the prudential standing doctrine for it not to apply.
Where do we get the power to do that anyway? If Congress says something very broad, where do we get to say that that's not good enough, they're going to have to do better? Where do we get that idea?
Because, Your Honor, Congress hasn't.
No, I know, but where did we get I understand where we get the idea with respect to Article 3. That's where we get that idea is from the Constitution. But with respect to prudential standing, where do we get the idea that we can say that even though Congress writes a very broad statute, no, sorry, we're not going to hear those cases. We're only going to hear much narrower cases. In Bennett, by the way, the Court said that prudential standing had been abrogated by the broad statute.
Yes, Your Honor. It's because this Court is concerned about the separation of powers, which is what the prudential standing doctrine is built on.
I'm not following. Separation of powers normally means if Congress says something and we're effectuating Congress's legislation, we do what Congress says. It seems like it violates the separation of Congress if instead we say, well, we don't care what you said, Congress, we want something narrower. That seems like the separation of powers problem.
Yes, Your Honor, except that Congress never intended for this statute to be interpreted
Well,
this
you keep
broadly.
saying that, and then you cite legislative history, but the statute says any person.
Yes, Your Honor, and according to the 1946 legislative history when they passed the Act, the Senate explained that Congress believed that there was no essential difference between trademark infringement and what is loosely called unfair competition.
Well, what precedents of this Court say that you're supposed to look at legislative history rather than the plain words of the statute?
Your Honor, I can't cite any precedent that this Court
I can't either.
Yes, Your Honor. However, Your Honor, it's interpreting what the congressional intent was, that there's limitations provided in the statute itself.
You realize that in 1946, there was no doctrine of prudential standing, right? This is a
Yes, Your Honor.
1970s doctrine. So
Yes, Your Honor.
why should we assume that in 1946, Congress was thinking about what we're going to do, not only how we're going to define commercial speech for purposes of the First Amendment 30 or 40 years later, but that we're going to come up with a doctrine of prudential standing 30 or 40 years later?
Well, Your Honor, Congress amended the Lanham Act in 1988, and in doing so, in describing, again, I apologize, Your Honor, but the legislative history discussed how it did not wish to extend or limit the standing
Right. But
inquiry.
they didn't change the liability section, did they? The section that we've been talking about, the one that says, shall be liable in a civil action by any person who believes. That section was not changed.
Yes, Your Honor, but prudential standing inquiries had been conducted up to that point.
So you think that if Congress knows that we have started an area of the law called prudential standing, and they don't change the statute, they leave the statute just as it is, amend a different section, that means that they really meant to change the statute to adopt our view of prudential standing?
Well, Your Honor, they did amend the statute in a way under the section that's relevant here, and they discussed that instead of simply providing a violation or a remedy to acts where a competitor claims that another party has made a false misrepresentation, that it can also be used against its own self for doing so. And so it had conducted, the courts had conducted prudential standing inquiries before that point in Quincy Cable Systems and in Floken.
Well, you don't think this rule only applies to cases in which you make representation, the prudential standing rule you're asking us to adopt doesn't apply only where there's a representation about your own goods, do you?
No, Your Honor, about others as well.
Do you agree with Petitioner's counsel that the determination of whether or not there's prudential standing is up for the discretion of this court? I thought you indicated that in your opening remarks. Please don't let me put words in your mouth. But do you agree that this is up to the discretion of the court?
Yes, Your Honor. The prudential standing doctrine is a judicially created doctrine by the federal courts.
Well, just because it's judicially created doesn't mean that it's discretionary.
No, Your Honor. It's only discretionary.
So that it isn't discretionary then?
Your Honor, it is discretionary in the fact that this court has to undergo an analysis.
Why don't we look to see how busy we are this week?
No, Your Honor.
We're not that busy, actually.
That's the D.C. Circuit that's not that busy. We're busy.
Your Honor, it's only discretionary in terms of this court's analysis of what Congress intended. And therefore, there is some discretion that's always given unless Congress had abrogated the prudential standing doctrine, in which there would be no discretion.
Do you have a citation to a case from this court that says that our determination of prudential jurisdiction, prudential standing, is discretionary? Can you cite me to any case?
No, Your Honor, I cannot.
Because it seems to me that that's altogether too imprecise a concept for what we're dealing with here, and we've pointed out to you the words of the statute. What are the factors that we should use in exercising this so-called discretion, or shall we say this judgment as to whether or not there's prudential standing?
Well, Your Honor, there's two different frameworks that have been used by the circuit courts. The Ninth Circuit.
There you go again. You're talking about the circuit courts. Tell us what you think we ought to do, because we don't have to do what they've done.
Yes, Your Honor.
Which framework do you want to adopt? Which one do you want us to adopt?
Your Honor, if we had to choose, which I don't believe we have to in this case, because both look to a competitive injury, I would choose the Ninth Circuit and the competitive injury test, which requires there to be a competitor and to prove or allege a competitive injury.
Well, when you say competitor, you mean a person at the same level. Is that right?
Not necessarily, Your Honor.
Well, I thought the problem that you thought Adams Apple here has is that they are a retailer and you are a manufacturer.
Yes, Your Honor.
That's their problem. That's their principal problem, right?
Your Honor, that's not their only problem. They simply do not compete with Aphrodite. Now, there are...
Right, because you're a manufacturer and they're a retailer.
Yes, Your Honor, but there are possibilities for a retailer to compete with a manufacturer.
Well, actually, you do compete with them online, don't you?
Your Honor, with the online sales, that is only 0.7% of Aphrodite's total sales.
What difference does it make what percentage it is of Aphrodite's sales? Don't we look at see how it compares to Adams Apple's total sales?
Yes, Your Honor, except I don't believe that
so
the
0.7%.
0.017%
doesn't, well, it's a little more than 10%.
Yes, Your Honor, but we don't
compare
believe...
it to Adams Apple sales. It's a
Yes,
pretty
Your Honor.
big chunk of, a pretty big competitor for them.
Well, Your Honor, we believe that if we look at the numbers at their face value as comparing apples to oranges. Instead, that 0.7% is different in several ways. For one, that the sales of Soleil are limited to 204 distinct locations, whereas online consumers can purchase Aphrodite cosmetics throughout the United States as well as throughout the world. Therefore, it is likely that much less than this 0.7% were actually competitive in nature, going from an online community to an individual grocery store market that is a specialty store. And so to try to compare these is is probably not the best way to do it.
Well, let's test your theory that there's something more to this than just the fact that there are different levels. What if Adam's Apple issued a press release claiming that Aphrodite products were cruel, that it was Adam's Apple and not PETA, or I mean LabWatch, that did this, and then all of your retailers switched to Soleil? Would you be able to sue anybody?
No, Your Honor, because Soleil would not be the person making that.
That's right. So if they arrange it so that the retailer is the one that does the dirty deed, you're stuck? You have no protection?
Yes, Your Honor, you do have protection.
What's your protection?
But not under the Lanham Act. Your Honor,
I
you
see.
could seek relief in state court under the Ames false advertising statute. You could also file a complaint with the National Advertising Division of the
So
Better
they have
Business Bureau.
they have a different prudential standing rule than you do, than the federal court does under the Lanham Act?
Your Honor, state courts don't have prudential standing. This is a federally.
Well,
created
if there's
document.
going to be litigation anyway, isn't that a strong factor in counseling us to exercise jurisdiction? There's going to be a lawsuit, there are going to be lawyers, we might as well vindicate the federal policy.
No, Your Honor,
And
because
if you're telling us that don't worry, there's a state cause of action, it seems to me that undercuts your argument that we should have no standing here.
no, Your Honor, we're not claiming that there won't be a lawsuit. We are simply claiming that the Lanham Act is not the proper forum because Adam's Apple cannot best effectuate the statute's purpose. Although there may be a lawsuit, this court has often denied standing to different litigants because it is not the proper forum. Just because it's not the proper forum it should not weigh in this court's opinion.
You say not best effectuate the statute's purpose. The statute's purpose is to prevent unfair misrepresentations of material fact about products and services. Why are they not in a good position to do that? They've sued you. They have very good lawyers. They've written very good briefs. Why aren't they in a good position to effectuate that purpose?
Well, Your Honor, under Gladstone Realtors, prudential standing serves to limit access to the federal courts to those litigants who are best suited to assert a particular claim.
Well, in this case, you think Soleil is best suited. They're not here. So I look around, I only see one other party. Why
Yes.
aren't they the best?
Because, Your Honor, there's two concerns here besides the separation of powers issue, which we discussed earlier. The first is the risk of collateral estoppel.
Collateral estoppel against who? You're concerned about Soleil might be collaterally estopped?
Yes, Your Honor.
They're not a party here. What case would collaterally stop them?
Your Honor, a future case that they may bring along with other manufacturers.
Why? They're not a party here. If these guys sue you and they lose, it's great for Soleil. Now they can come in and sue you again. What makes you think that they'd be collaterally stopped for any reason?
Because, Your Honor, they're removed from the cosmetics market, and so they lack the strategic expertise to understand how competition in the market works.
Well, we're the ones who have to figure that question out. If that's true and they put on very bad experts, they will lose.
Yes, Your Honor, and if this court or a lower court decides that there was not a misrepresentation, although the cosmetics industry has its own specific framework and its own specific description of what a misrepresentation is, then Soleil or other manufacturers could be collaterally stopped.
I'm not following that. Soleil will come in. You will say, sorry, this has been decided. They will say, sorry, we weren't in that case. It doesn't bind us. Can you tell me a case that would bind them when they were absent, they were strangers to the litigation?
Well, Your Honor, it's in terms of the issue preclusion that the issue being decided.
All right, but issue preclusion normally applies either offensively or defensively to somebody who actually participated in the litigation. Soleil is not participating in any way.
Your Honor, we don't have that fact before us. We only have this case. In addition, Your Honor, besides collateral estoppel, there's a risk of duplicative suits.
But these matters really are not proper forum. You suggested that the question is the proper forum. It seems to me the question of prudential jurisdiction is whether or not the suit is manageable and within the judicial competence. So it's not just judicial forum.
Yes, Your Honor. In terms of not only the judicial forum, which again we say that the Lanham Act would not be able to be brought in this forum, does not preclude it from being brought in state court.
Let me ask you a somewhat different question. Your time is running out. Excuse me for interceding in your answer. Is your case strengthened by the fact or weakened by the fact that this is an exclusive distributorship arrangement?
Your Honor, it's weakened by that fact. that Adam's apple probably has a more direct injury. However, it still doesn't.
No. The question is, suppose there were multiple distributors. It would seem to me that then your argument would be better. It seems to me their argument is somewhat enhanced by the fact that it's an exclusive distributorship.
Yes, Your Honor, it would have a more direct injury than before, but that's not
you would agree that that's a point in their favor, even though not dispositive, of course.
Yes, Your Honor, because it does not prove a competitive injury, which is required.
Would you not go on to say that the law should be cautious about giving special advantages to exclusive distributorships? Is there anything in the law that encourages exclusive distributorships?
Your Honor, nothing that will come to mind. Thank you, Your Honor.
Thank you. Ms. Maimin, good evening.
Good evening. Mr. Chief Justice, may it please the Court, Tian Maimin for Aphrodite Cosmetics. Your Honors, this case is about whether a company's engagement in public discourse over an issue of public concern should remain within the protection of the First Amendment.
Why? Again, I want to ask you the same question that I asked the other side, not the one about Dean Kagan, the one about the words of the statute. Why should we care whether this is under the First Amendment? There isn't a constitutional claim here. We have a statute. You say that the misrepresentations have to be in advertising. The statute says advertising or promotion. You say that the misrepresentation has to be about a specific product. Again, looking at a First Amendment case, the statute says any good or service. Why should we be looking to cases that interpret the First Amendment when this case is brought not under the First Amendment but under the Lanham Act?
Well, Your Honor, lower courts have taken the First Amendment doctrine of commercial speech.
Those dirty words again.
If this
Lower
court
courts.
chooses, this court could certainly choose to construe commercial advertising and promotion as used in the Lanham Act differently and narrowly. However, if it chooses to construe it more broadly than this court's First Amendment commercial speech category, then it has to address those First Amendment values because they are implicated. A lawsuit, a competitor seeking to sue another competitor under the Lanham Act.
Now, don't we take it as a given in this case, and you don't need to accept this characterization if you disagree with it, but shouldn't we take it as a given? It will be subject to proof in the trial court, that there was a representation. That representation influenced the buyer in a material way. The buyer relied on the truth of that representation. The buyer purchased the product. Standard basis for recovery when there's a misrepresentation of a material fact, basic torts. And the Lanham Act, of course, is a federal statute with an overlay, but it's essentially a basic tort.
Your Honor, it's unlike that context. So certainly a suit could proceed in a basic tort context without using the words commercial speech.
I want you to buy my product, and I lie. And my lie causes you to make the purchase, and if you'd have known the truth, you wouldn't have bought it. Why is that not actionable? And isn't that what happened here? Assuming it's proved at the trial court, in the trial court.
Right, that's what's alleged has happened here. That is actionable. That could be actionable. We're saying it should not be actionable under the Lanham Act. Currently, the way the Lanham Act is applied, the courts do look to whether the speech...
Do you agree that that would be actionable in tort?
Yes, Your Honor, because
I thought you said that's a First Amendment privilege.
Yes, Your Honor, because outside of the Lanham Act context, a determination of whether speech is commercial or not usually only affects the degree of scrutiny that's applied to that
You mean
speech.
we're going to have two standards. One is what is commercial speech for the Lanham Act, the other for a state tort?
Your Honor, I believe that would result in some confusion.
I mean, quite without regard, our obligation to try not to confuse the public with our jurisprudence, it seems to me to be illogical.
Your Honor, we're not arguing for different standards per se. What we're saying is that...
Why not? It seems to me that you must.
Well, we're saying that commercial speech is going to be the same thing it is here as it is anywhere. However, there would be a different set of concerns that's implicated as to whether a private litigant can bring a fraud suit or whether that private litigant can bring a Lanham Act litigation. That's a difference, and that affects whether this court should call Aphrodite's speech commercial and thereby allow Lanham Act litigation to proceed, or whether it should not.
Well, why do you focus on whether it's in an advertisement? What if the language that I'm interested in is the language from the letter to the editor, which says, "We pledge to cease all testing of our cosmetics on animals, a pledge we have kept." Now, if that were in an advertisement, would that be a Lanham Act violation?
Yes, Your Honor.
So the only difference is that it's in a letter to the editor?
That's a big difference, Your Honor.
Well, I'm not sure why that is.
Well,
Imagine, let me give you the Kong is still a fancy restaurant around here, isn't it?
Yes, Your Honor.
So imagine they wrote a letter to the editor, and they said, I don't know, we don't have MSG in our food. And imagine arguendo that was false. Why is that any different than if they plaster on the front of the restaurant, we don't have any MSG in our food? What's the difference? Why should it make any difference?
Well, there's two differences, Your Honor. First, form and context matter, because if we take out the form and context of speech in construing what should be called commercial speech, there are potential very serious chilling and suppressing effects on speech that the First Amendment does give protection to. Speech made by corporate actors in, say, the CEO of Microsoft on a college campus debate. Speech that...
Yeah, but that's not our case. I understand that could be a problem, but that's not our case. What you have here is the head of communications, namely the press person from your company, has written a letter to the editor. It's not like, you know, some well-known columnist like Fenno from the Harvard Law Record has written a column. It's the person whose job it is to make up advertisements. Why is that person going to be any more chilled if the exact same copy is in an ad and is challenged as if the exact same copy is in a letter to the editor? Why does it matter?
It matters because, well, it matters because when a company can't order its speech by knowing that if it speaks in certain forums, it's going to be subject to stringent rules and has to make extreme caveats and has to make sure that each of its statements is subject to really only one reasonable interpretation. When that's not delimited by forum, but essentially extends to everything it does, to writing letters to the editor, to college debates even, that companies will essentially stop speaking on some sort of issues.
So
what cases do you have from this court where we make a distinction in the forum that the speech occurs in as opposed to the content of the speech?
Well, Your Honor, we think that the two Bolger factors point to form and context, and lower courts, such as the Sixth Circuit and Semco and the Southern District of New York and Gordon and Breach projects have looked at commercial
you're talking
usage.
about the commercial context. I'm talking about the manner in which the speech is disseminated, word of mouth, the hypothetical my colleague gave with reference to something on the menu or a sign in front, a letter to the editor. Well, what in our court jurisprudence makes a distinction in where the speech appears? We're interested in the truth or the falsity of the content and whether or not the speech is protected as such.
Your Honor, we are interested in the truth and falsity. We're arguing that form and content allows this court to draw the category of commercial speech. That focusing on these two factors does not particularly
So then the
well.
letter to the editor is the same as an advertisement, and you have to change your answer.
No, Your Honor. We are looking at the prongs of the Bolger test and looking to its use of the word advertisement and to
Well, but
forums.
isn't the problem, the fundamental problem with that argument is that advertisement is so elastic these days? Like, was an infomercial, would that count as an advertisement as far as you're concerned?
Probably yes, Your Honor.
What about a product placement? You know, in movies where they feature the Ford and Ford pays a substantial amount of money, is that advertisement?
I think so.
What about a website? Is that advertisement?
That's more difficult.
A press release?
That is not an advertisement.
That's not advertisement.
Your Honor, there's a fine line. There's fine lines to be drawn here, but the court has to draw the line. We're arguing the forms of engagement
Well,
that
I don't
Aphrodite
usually, I don't know
did not
that
meet.
if we make these fine lines when the issue is protected speech, and you're saying that some forums, some media are preferred over others.
Your Honor, not that they're preferred over others, but the balance of harms works out in some contexts better than they work out in others. So when speech is in the form of a label or the form of an advertisement, there's much less chance for consumer reflection. There's a greater likelihood of
Yeah,
harm.
you keep saying that, but and you said that it was in our cases, but I've gone back and reread them, and there is that one statement by our colleague Justice Stevens, which talks about reflection. Well, it seems to me that here, there's plenty of time for people to reflect. There's certainly as much time as there was in Bolger.
Your Honor,
I don't really understand what that's all about.
Your Honor, that isn't the key thing propping up our argument. That's one of the ways in which one understands why keeping commercial speech, looking at form and context may be important in distinguishing commercial from non-commercial speech. And that's a psychological understanding of spur-of-the-moment decisions in which the public should be protected against. However, when company speech is put in the form of, say, a letter to the editor or reported to a reporter, then that can be vetted in a way, it can be scrutinized in a way that labels are not. If speech is put in the form of a letter to the editor, competitors who feel harmed, the public who wishes to say something, can also write a letter. This does not have the same entry, high costs of entry that an advertisement, an expensive advertisement campaign would have. It is in these forums also in which the court has said that, for instance, companies' direct statements on public issues receive full First Amendment protection, and that's often used as a justification for why company speech can be regulated when they are only in the proposal of a commercial transaction.
I guess I really don't understand the emphasis on advertisement. It seems to me in response to one of my colleagues, you said, but for the fact that this isn't an advertisement, it would meet the Bolger, it would, as far as you're concerned, there would be commercial speech here. Well, in Bolger, we expressly said that you didn't need an advertisement.
That's right, Your Honor.
So if you don't need an advertisement, and but for the fact that this isn't an advertisement, it is commercial speech, where does that leave you?
Well, it still leaves us that the speech should not be regarded as commercial. So it is true that an advertisement, the fact of an advertisement alone is insufficient to make something commercial speech. The reason that we look to the Bolger factors is because they are important considerations in determining whether something can be regarded.
Besides the advertisement, what's the other factor?
The second prong is reference to a specific product.
So that's, you'll have to help me why that's relevant also. So here they say, our products, or our you say, our products, our cosmetics are not tested. That's a reference to all of your products. Do you think it would make a difference if they said the same thing but said our eyeliner isn't tested? That's the difference between our cosmetics and our eyeliner?
No, Your Honor, we don't. It wouldn't make much of a difference.
So when you say specific, what do you mean? Why isn't this specific enough? It's not a description of generic cosmetics. They're talking about, Aphrodite's talking about Aphrodite's cosmetics.
Yes, Your Honor, that's true. We're using the Bolger prong and looking to the Bolger prongs as evincing an underlying reason for why commercial speech should be treated
I
differently.
understand, but what's not specific about the statement that our cosmetics are not tested on
I thought you
animals?
acknowledged it was specific enough, that you met the other prongs of Bolger. The only thing you don't meet is the fact that it's advertisement. Is that right?
I think we also say we don't meet the second prong either.
I thought in oral argument, though, you conceded that you haven't conceded then.
Oh, I haven't conceded, Your Honor.
Okay, well then proceed to answer my colleague's question.
Could have gotten out of it, but just to rephrase the question, so why isn't this a specific representation or misrepresentation?
Your Honor, this would come under Petitioner's test. Indeed, Aphrodite made a factual representation about its business operations or products. We're not denying that. We're saying this should not be treated as commercial speech, and that test shouldn't be used as commercial speech because of the ill consequences on the First Amendment from doing that.
I thought your argument was that the Bolger test is the right test, and this doesn't really, this isn't commercial speech because it's not an advertisement, which is one of the things in a test, right?
Yes.
And we talked about that already. And the second reason I thought was it wasn't about a specific product.
Yes.
All right, and I want to know why you think this isn't about a specific product.
Well, Bolger looked specifically in whether there was a reference to a specific product,
Right.
and when that is literally applied, Aphrodite did not make any references. However, footnote 13 in Bolger did say that a specific product reference was not necessary if a company, say, had a monopoly over a market.
But when Bolger was talking, using the word specific product, my reading is that they mean the difference between a generic statement about all cosmetics, for example, or in that case, all of a particular kind of item, or a brand name, a specific brand. Not that it has to be eyeliner, not that the statement has to be about eyeliner and blush and everything else separately. So that sounds to me like you're conceding, really, that they have met the specific product requirement.
Your Honor, what I'm conceding is that it really doesn't matter whether they've met the specific product reference or not.
Well, if that's the case, you said that this meets you win on the Bolger test, right?
Yes.
And if you give up on the specific product, and there's no doubt that there's an economic motivation, you have only one thing left, which is the advertisement, right?
Yes, Your Honor. The Bolger test, however, does say that, I mean, it's more of a balancing of totality of circumstances test. It says that none of the factors taken alone are sufficient to point out commercial speech, and
May not be sufficient.
May not be sufficient, and then the three factors all combined together strongly suggest that the speech may be
Well, is there
commercial.
some other factor? Are you now espousing a new test, too?
We're not.
We're
Your
open
Honor.
for...
You're not. We are in full support of the Bolger test.
Well, with reference to new tests, should we consider simply abandoning the distinction between commercial and non-commercial speech? That's been suggested, has it not?
To abandon the distinction?
Yes. I mean, what purpose does it serve? Is the underlying concept somehow that commercial speech is less important?
The movement in this court seems
If I
to
go
be
down
it's
to the
not.
sidewalk and ask somebody, I'm interested in two subjects. One, are you a Neoplatonist? The other is, what kind of car do you want to buy? I'm sure most of the people would be much more interested in the latter. That's commercial speech. Why should we have this distinction?
Your Honor, the distinction, I agree, is not necessary. However, it was put in place for some reasons. There was a historical development behind it. It was to extend First Amendment protection to speech the government had been regulating because it called it commercial speech, and said that it could regulate it without the court being able to scrutinize under the First Amendment. So the commercial speech category began as a way to afford First Amendment protection to speech that was merely in proposal of a commercial transaction. And then commercial speech was given a lower degree of scrutiny, and that was justified by the fact that government can regulate commercial transactions and should be able to regulate speech that was tied to that transactions. And we are arguing that the Bolger test really does capture this concept well, that by focusing on the form and context of speech, whether it's in the form of advertisement, and also to a lesser extent whether it makes specific product references, because indeed this often happens on a label or an advertisement, that the court can effectuate the underlying First Amendment interest, which is not to chill and suppress speech, but also to address public harm as the result of that speech. Oh, thank you, Your Honor. I see my
Thank
time.
you, counsel.
Thank you.
Rebuttal from the petitioners? Mr. Harold, you have quite a bit of ground to cover, I know. I am interested in the question I asked respondents. It seems to me that you make quite a point out of the fact that there's an exclusive distributorship arrangement here. Does the law really favor exclusive distributorship? So an exclusive distributor has a better grounds for recovery than a non-exclusive distributor, or do you not rely on that at all?
I think the exclusive distributor agreement would speak to the fact that it would have been difficult for Adams Apple to avoid the damages, which is one of the things that Respondent claims. If indeed there was the type of exclusive distributor agreement in place that precluded us from being able to stock our competitors' products, then that would be an inappropriate means for denying prudential standing. Although Respondent contended that there were more appropriate means and venues for providing Adams Apple with the remedy, that is not a reason to deny Adams Apple standing in this case, when its claim falls within the Act's plain language and implicates the false advertising issues Congress addressed within the Lanham Act. Furthermore, adopting Respondent's strict advertisement requirement would provide companies with the incentive to use emerging technologies to disseminate their false representations, which may indeed harm consumers. As such, we ask this Court to reverse the lower court's holding and grant Adams Apple prudential standing and find Aphrodite's speech commercial. Thank you.
Thank you. The case just argued will be submitted, and the Court will be in recess for approximately 15 minutes.
Excuse me. We're ready to get started. If everyone could please have a seat. While everyone's getting to their seats, the judges will be here in just a minute. I would like to invite all of you to a reception immediately following the decision in the Ropes Gray Room in Pound Hall, and that reception is open to everybody. Thank you.
All rise.
Thank you. All of us were delighted to be invited to attend this argument in this historic room, and we thank you very much for being a patient and a responsive and generally an alert audience. And of course, we thank the petitioners. Each of my colleagues would like to make some remarks before we conclude. After we conclude, we're going to meet with the members of the teams and have a reception. My distinguished colleague from the United States Court of Appeals for the Fourth Circuit, Judge Diana Motz.
Thank you, Justice Kennedy. It really is a pleasure for me to be here today, and particular pleasure to serve with two such distinguished alums of this great law school. And I have to tell you from the get-go that these were the four best oralists I have ever heard. And that's true. You really did a fine job, and I know that sometimes judges ask questions that really, you know, they shouldn't. They aren't the appropriate questions, and what are they thinking of? And but that is the way it is in real life. Lawyers feel that way too, you know, when we ask them questions, that they aren't the right question or that we're off the page or something. I thought the briefs were very good. They were, to me, they read more like a law review article in some instances than like briefs. But since we all know that you all really want to be professors, maybe that bodes well for you. In real life, people tend to be a little more adversarial, shall we say. But your discourse in the brief was on an extremely high level. And I credit the petitioners with coming up with a new test and a new presumption and a new this and a new that. I mean, they recognized that they were in front of the Supreme Court of the United States and they had an opportunity to go there. I credit the respondents with recognizing it's pretty dangerous to be telling the Supreme Court that they haven't been clear before and that their test doesn't really meet everything. So in sum, it was really an excellent argument. I gather we're going to have an opportunity to talk to the two teams alone, and I think it will be interesting to discuss the problem, which I thought also was excellent.
Thank you. And my distinguished colleagues from the United States Court of Appeals for the District of Columbia Circuit, Judge Merrick, Garland.
Thank you. I think when Judge Mott said that the four best oralists, she wasn't talking about moot courts. We're talking about what it's like in
real life.
In our actual courts. From the point of view of the way we questioned you, the only real differences were in the real situation, fewer jokes, and you have less time to actually say anything you want to say, right? So we would jump in probably before we get even a word or two out of your mouths. The reason I thought you folks, all of you, were so good was that you really have adopted what I would describe as a modern oral argument. There was a time for most of the last century, it's great talking about the last century, but for most of the last century when the role of the lawyer was to harangue the court in quite beautiful rhetorical language, to give a speech, to go through the facts, and then what the arguments were. It's completely changed now, and it's very much the way it is here. The judges have already read the briefs, they've read the cases in the briefs, they've read the record described in the cases in the briefs, and now is a time to have a conversation between the oralists and the court about what the law is, what the problems with where the law is, what will happen if we take your position and take the next step. And each of you was willing to engage in that kind of back and forth, not to just talk at us, not to just stick with one position, but really to go back and forth, to explain why is this the test you want, to explain that's why this is the test we want. That is a ability that there are actually very few lawyers in private practice who have yet figured out is the only ability that will enable them to win an oral argument or to advance their client's cause in oral argument. And I don't know who taught you this. I assume it's the Harvard Law School. They've done a very good job, and we thought it was really great.
What you've seen tonight is of tremendous importance. We warrant, at least implicitly, to the community at large, that we are skilled in the art of rhetoric and persuasion and analysis. And you must know this art. You must know this skill. That's what distinguishes you from accountants and business consultants. Don't think that this is just an add-on to an education. This is right at the very heart of your education. And I agree with Judge Garland that argument styles have changed. A really good argument, most of the public think of as like a debate, but it's really like a quiet discussion of a doctoral thesis. Your time is limited. We had many more questions that we wanted to ask you, and this happens very much on my court. The English are horrified that we have just 1 hour per case. They have a great tradition of orality there. I was sitting on the House of Lords, sitting as a visitor, not exercising in judicial capacity.
You're still
and
It's great in the wig, though.
The counsel, the barrister, said, "And now, my lords, I wish to turn to the statute." and we all knew what was coming, the statutory construction, and the canons of statutory construction cancel each other out, like Provis stitch in time, save 9, haste make waste, I have one for either side. So the presiding judge said, "If counsel begins to quote the maxims of statutory construction, I shall be forced to leave the room." And to which the counsel replied, "Oh, my lord, I would not wish to precipitate such a calamitous event." And we don't have time for that stuff. Now, at moot courts, it's expected, it's conventional, it's almost ritualistic for the judges to congratulate the oralists and the brief writers and to say that this was an excellent argument, even by the standards to which they are accustomed in their own distinguished courts. In this case, it's, of course, a pleasure to follow that convention, but in this case, it happens to be very true. To begin with, this was an excellent problem. I know how hard it is to write moot court cases that really grasp the attention and the interest and the fascination of the counsel. And then there's, in order to have an issue on both sides, we had a jurisdictional issue which sometimes seemed contrived. Here it meshed quite nicely. This was a difficult problem, and extremely well argued. The briefs were good. I have to tell you, I've been reading briefs for over 30 years, and I've yet to find one I can't put down in the middle. But these were excellent. And I put them down only a minimal number of times. When I came here tonight, my wife said, "You've got so much work to do, and you're putting down a real case for a pretend case." And I said, "Look, this is real. The law isn't just made in courts by a bunch of judges. It's made in the law schools. It's made in the interchange that you have in class. It's made in your study groups. It's made here. It's part of the seamless web that forms the language of the law, that solidifies the law in our consciousness and in our beliefs and in our culture. So this is very real, in a sense, and you will remember it, and you should do so. This is the law in action, and each of the judges on the bench come away with a better perspective, a new perspective on the law and its meaning, on the difficulties of these issues. It is merciful that we do not have to decide this case. This is a very difficult, very close case. We have 3 awards to announce, and we had considerable difficulty because we thought it was really very close, and there is merit, strong merit, to all of the briefs and to all of the arguments. The first award is for the best briefs. We thought the blue and the red brief, if we had just those, we thought maybe the red brief had a slight edge, but we thought the yellow reply brief was quite powerful. The presumption that was mentioned, we found not too substantively strong, but on the other hand, the respondents didn't attack the presumption that much. So on balance, we awarded the best brief to the petitioners, the blue and the yellow brief. Congratulations. Oralists, difficult because we wanted, number one, we were interested in the case. I had a lot of questions I wanted to ask, and we had to try to divide the time evenly so that we didn't intrude on the time of the advocates. There was a question of style, presentation, poise, which is important. There's no one way to make an oral argument, and you have to make an oral argument based on your own personality, your own dynamic. And we thought all of you were sincere and presented yourselves, your real selves, very well in the argument. We gave a strong weight in the oral argument, though, to substance, not to style. And we thought on substance, although it may not be the side of the case that we agreed, that the best oralist was Chien Minamin. Although we thought the blue and the yellow brief had a slight edge over the red brief of the respondents, we thought the respondents' brief was also excellent, and we thought, therefore, that the stronger team was the Shirin Shakir Memorial Team. Congratulations. With repeated expressions of appreciation and gratitude for your having invited us here and for your obvious commitment to the law and the legal system, we thank you, and the court is now adjourned.
All rise.